When Supreme Court cases are decided, especially big cases of national importance, what comes to mind? Probably two sides submitting extensive written briefings, oral arguments between attorneys, and rulings by a court that explains the majority's legal reasoning behind a decision and an important dissenting opinion. And since Trump's first term remaking of the court into a 6-3 conservative supermajority, there's been a lot to worry about among those decisions, the ones made on what's known as the merits docket. That's the Supreme Court's main docket of cases. But more recently, there's been a surge of increasingly consequential issues that are decided on the High Court's so-called shadow docket. You may have heard the term, but it bears underlining what it means. Now, think of that process I just laid out. Written briefings, oral arguments, written rulings, everything out in the open. Now toss all of that aside. The shadow docket short-circuits that process. It's made up of cases that are emergency appeals, asking the Supreme Court to overturn lower court rulings while litigation continues. It's not designed for thoroughness and transparency. It's designed for speed. Here's how this works. Any litigant can send their emergency application to a Supreme Court justice who then decides whether to present it to the full court. It takes a simple majority, 5 votes among the 9, to grant an emergency request. Remember, there's a 6-3 majority on the court right now. Cases need to meet certain criteria to be on the emergency docket, including whether applicants would suffer, quote, irreparable harm if their request to block a lower court order was denied. So far this year, the Trump administration has filed 28 emergency cases on the shadow docket. That's an unprecedented number. The Supreme Court is not deciding on the merits of these shadow docket cases, so it's not issuing final rulings. It's kicking the can down the road. But the judicial edicts handed down in the shadow docket are often issued without any explanation whatsoever and have immediate impact. The process here matters, and federal judges appointed by both Democrats and Republicans have spoken out about the surge in shadow docket cases before the court in interviews with NBC News. They describe, quote, lower court judges are handed contentious cases involving the Trump administration. They painstakingly research the law to reach their rulings. When they go against Trump, administration officials and allies criticize the judges in harsh terms. The government appeals to the Supreme Court with its 6-3 conservative majority. Then the Supreme Court, in emergency rulings, swiftly rejects the judges' decisions with little to no explanation. 10 of the 12 judges who spoke to NBC News said the Supreme Court should better explain those rulings, noting that the terse decisions leave lower court judges with little guidance for how to proceed. Now, for much of its history, the shadow docket has largely been reserved for appeals related to the death penalty, which makes sense. These are obviously time-sensitive cases, and there's clearly a potential for irreparable harm when a litigant's life hangs in the balance. But emergency requests have surged, as I mentioned, under President Trump. They're deciding consequential matters that affect all of us and make one question the real irreparable harm that is apparently being averted. The administration invoked the shadow docket in legal challenges to the mass firing of federal employees. Earlier this month, the Supreme Court blocked a federal judge's ruling restricting federal officers' ability to conduct immigrant sweeps in Los Angeles. The administration claims ICE agents can stop and question people based solely on their appearance, their accent, and the type of work they do, not, as the Constitution writes, on reasonable suspicion of a crime being committed. Trump's Justice Department appealed to the Supreme Court's shadow docket and got exactly what it wanted. The lower court decision lifted, and the High Court's blessing for ICE agents to continue these broad sweeps in Los Angeles. So you would think a decision as consequential as that, whittling away at our Fourth Amendment protections against unreasonable search and seizure, warrants an extensive ruling laying out the legal reasoning. But that's not what you get with shadow docket cases. In most rulings, there's little or no explanation and even less transparency. Just yesterday, the Supreme Court handed another victory to the Trump administration using the shadow docket by allowing it to unilaterally freeze $4 billion of congressionally approved foreign aid while the litigation plays out. The real question is why the High Court, over and over again, acquiesces to Trump administration appeals, handing more and more power to the executive branch by granting not only these emergency requests on the shadow docket, but even agreeing to the very premise that these are, in fact, emergencies. Joining me now is Mark Joseph Stern. He's a senior writer for Slate who covers the courts, and Jeff Rosen, who's the president and the CEO of the National Constitution Center. He's also a law professor at George Washington University Law School. Welcome to you, gentlemen. Thank you for being with us. Jeff, let me start with you, because I hope we've made clear there is a reason for something like the shadow docket. It's not like something like this should never, ever be used. There's a concern that it's being used more regularly and perhaps not as properly as intended.
That's exactly right. The main argument against it is that by not providing reasoning, it doesn't allow lower court judges any guidance about what to do. And Justice Ketanji Brown Jackson memorably put it in a recent case. She said, Calvin Ball has just one rule, there are no rules, and we've added another, the administration always wins. So the criticism against it is the court is repeatedly ruling for the administration without providing any reasoning, leaving lower court judges to guess. The argument on the other side, Justice Barrett has offered, and she says that it avoids what she calls the lock-in effect. By not ruling on the merits, you don't commit yourself to reasoning that you then have to apply in future cases. And she said that gives the court flexibility to rule against the administration in future cases. But this is going to be the big term when we see whether there are, in fact, any major cases in which the Supreme Court is willing to challenge the administration.
And in these tricky times, Mark, Jeff and you read these decisions, you read the dissents. We learn a lot from you about that stuff. But people are more concerned about the Constitution and constitutionality now than they have been at any point in recent memory. So this idea that decisions are made that have an impact on people without our ability to hear and analyze the reasoning is what is the cause for concern here, I would think.
That's a big part of it. You know, the court earns its power through explaining its work. It earns its legitimacy by telling the American people, this is how we reached this decision. This is why we're imposing this judgment on the country. And when the court doesn't even bother to do that, when it issues a major decision without saying, here's our legal basis for doing so, it leaves a lot of people wondering, is there even a legal basis, or is it really just politics driving this decision making? I also think that it's especially alarming when the court issues decisions that fundamentally upend the separation of powers in our constitutional system. That is what happened yesterday when the court allowed President Trump to unilaterally cancel $4 billion in foreign aid. You know, the Constitution assigns Congress the power to appropriate funds. It directs the president to faithfully execute Congress's commands. And yet, for really the first time ever now, the Supreme Court has allowed Trump to just take a line item veto to money that he doesn't want to be spent. That money will now expire on September 30th. And so even though the court claims that this is all about interim relief and, taking an early look in an emergency, the reality is that this was a final judgment.
So, Jeff, this is important because you and I have several conversations about the administrative state and merit docket judgments that have diminished the power of independent agencies. But this question of separation of power is different because this was literally a question of money appropriated by Congress and whether the president has a role in being able to affect that. So I guess that's the issue, that there are emergencies and things that have to be done, but there are some basic principles here that are being addressed through the shadow docket that deserve different treatment.
That's exactly right. And the big principle that you both identified is Congress's power over the purse. And in a series of Supreme Court decisions, the court has held that Congress can prevent the president from refusing to spend money. It's called impoundment control. The court in the past had upheld Congress's power. It seems on the verge now of perhaps overturning those decisions and giving executive broad power over spending that he hadn't had before. Similarly, when it comes to the administrative state, the court seems to be on the verge of overturning a case called Humphrey's Executor, which had upheld the constitutionality of independent agencies since the 1930s. What's so significant in both of these areas is the court is essentially signaling that it's about to majorly shift the law and almost inviting lower court judges to predict which way the law is going rather than applying the existing precedents. Some of the justices have suggested as much in several cases. The objection there is it invites chaos.
The Federal Trade Commission case before the court challenging the president's firings of certain commissioners, Justice Elena Kagan warns that the court is effectively reshaping, as you discussed, the separation of powers by granting so many emergency requests. But again, there are serious implications of this. Firing commissioners on the Federal Trade Commission, trying to get Lisa Cook on the actual Federal Reserve Board fired, which they're also asking for emergency treatment of. These are massively influential to how we see our democracy.
Yes, I mean, from the very start of this country, from the first Congress, there have been independent agencies that are shielded from partisan corrosion and from direct presidential control that are tasked with the important work of regulating our economy to make sure that the president can't just jump in and tank the economy or do whatever he wants with it for short-term gain. For many decades, almost 100 years, the Supreme Court has expressly said that it is perfectly constitutional for Congress in creating these agencies to limit the president's control over them. And over the last few months, the Supreme Court has blown that up. In a series of shadow docket decisions, the Supreme Court has allowed Trump to fire so many agency leaders who were protected against removal under federal law. Those moves by Trump, firing those individuals, it was brazenly illegal. It went against 90 years of precedent. One might think that even if the Supreme Court intended to overturn that precedent eventually, that it wouldn't want Trump to jump the gun, that it would want to reserve its own power to overturn precedent and not let Trump just do it for them. And instead, the conservative supermajority has again and again allowed Trump to fire these individuals, allowed him to break the law, and given him unprecedented control over the federal government. It is deeply alarming. It has thrown lower courts into truly chaos, as Jeff said, because they don't know what they're supposed to follow now. Do they follow the precedent that's still on the books, or do they try to read the conservative justices' minds to see where they might be going tomorrow? There is no good answer. And to make matters worse, several conservative justices have openly scolded and chastised lower court judges for failing to read their minds. So this is no way to run a railroad. It doesn't look a lot like a court engaged in judicial decision making. It looks like a court rapidly altering the law so that it can give Trump as much power as he wants.